If you're married and filing a Chapter 7 bankruptcy, there are some specific rules that apply. The rules depend on whether you file jointly or not and whether you live together or not. And that's the topic of this video. Hello again, everyone. I'm attorney Robert Flessis. If this is your first time here, now might be a good time for you to subscribe. By subscribing, you know where to go for legal answers. I received a good question from a viewer regarding the treatment of a spouse when preparing to file bankruptcy. I'm going to tell you about 4 different types of situations and how they're treated. The first 2 situations are when you are filing jointly with your spouse. The difference is whether you live with your spouse or not. If you live together and file jointly, your household income, monthly expenses, and assets are combined in the petition as a whole. That's the easiest one. One spouse is indicated as debtor 1 and the other spouse is indicated as debtor 2 or joint debtor on the Bankruptcy Form 101. If you're filing jointly but you live in separate households, you would still designate each spouse as debtor 1 and debtor 2. But the only difference on the petition is that each spouse will report their own individual living expenses separately for their own individual household. You still report both incomes if you both still work. The next 2 situations are when one spouse is not going to file and whether or not you live together. If you live together, then you indicate on Form 101 that the spouse that's not filing as the non-filing spouse. There's a checkbox for that designation on the petition. Even though only one spouse files, both of your incomes must be indicated in the means test. You do this because you're living together and sharing the same living expenses for the household. If the non-filing spouse has a higher income than you do, then the means test may not qualify the filing spouse for a Chapter 7. But you may be able to qualify if you use the marital adjustment for the non-filing spouse, and that's a whole different video. Now let's say you're married, only one spouse is filing, but you live in separate households and deal with your own living expenses. You don't have to report the non-filing spouse's income or expenses because they're not filing and you're separated. Neither of you contribute to the expense of the other's household. You only need to report on the petition the name, address, and social security number of the non-filing spouse to point out that you're still married. Well, I hope I didn't confuse you. I'm attorney Robert Flessis. Thanks for watching. Remember to subscribe, like, and share, and I'll see you in the next video.